And I'll call the fifth case on this morning's docket, case number 119658, in the matter of Rebecca A. Hamilton, in order to show cause.
May it please the court, Stan Hazlitt, appearing from the Disciplinary Administrator's Office. I would request reservation of 2 minutes, please.
2 minutes is granted.
This is an original proceeding in attorney discipline. We are here today as a result of an order to show cause this court issued to respondent to appear before the court today. I don't want to give the court a procedural history of this so that everyone understands what happened here. There was a panel hearing that began on March 30th of 2017. That wasn't enough time to present all the evidence, and so the second day of the hearing occurred on December 8th of 2017. I know that's a lot of time, but the respondent experienced some medical difficulties in the interim, and the case was continued on a couple of occasions.
The case was that at the request of Ms. Hamilton, those continuances? Or was it due to something with the Disciplinary Administrator's Office?
No, I think there were two, and at one point Ms. Hamilton was in the hospital with a shoulder surgery, or shoulder injury, I'm sorry. The case was docketed with this court on July 9th of 2018. The respondent then requested some additional time to file her exceptions until August 3rd, which were due on August 3rd. This court granted her time to file the exceptions until August 29th of 2018. At that time, this court said that no additional time will be allowed, no additional extensions of time will be allowed to file the exceptions, absent exceptional circumstances. The exceptions were not filed on August 29th of 2018. This is kind of a fluid situation, so I hope you'll bear with me. I talked to the clerk's office this morning, and I've talked to the respondent in the attorney lounge. She made an attempt to file the exceptions last night at 4:30 in the morning. The clerk rejected that attempt because there was not a motion accompanying the exceptions asking to file the exceptions out of time. But there was that attempt early this morning to file the exceptions. The respondent, as we talked in the attorney lounge, indicated to me that she would show me the exceptions. I think they're about 70 pages long. I wouldn't have had the time to read them, but I saw them. I see that they exist, but they have not yet been filed. So exceptions due August 29th of 2018, and on September 10th of 2018, the respondent filed a motion to stay these proceedings, in which the respondent requested a 30-day stay, and it was requested to what she described as physical and emotional issues that she was experiencing, and she was just not able to get done what she needed to get done. She stated in the motion that she has struggled, I quote here, for survival, in trying to meet deadlines without much success, and that the 30-day stay requested to address health and personal matters. She requested that stay to address these health and personal matters, to complete the exceptions which she acknowledged were overdue. Deb Hughes of our office handled this matter at the panel hearing level, and she filed a response to the request for the motion for a 30-day stay. She opposed that stay. In fact, if the court had granted that stay on the date that it was requested on September 10th, we would be 44 days down the road. The respondent would have had the 30 days. Our position is that we oppose the request for a stay, and this is the part of the fluid part of it again. In my conversations with the respondent before we came in here today, it's my understanding that she no longer wants a stay, that she's ready to start up again. She hopes, I think, that she would accept her exceptions to the findings made by the hearing panel, and that she wants to see this thing through to its conclusion. I think that's her position at the present time. That still leaves the issue that Ms. Hughes brought up in her motion about whether or not the respondent is capable of defending herself in this disciplinary proceeding. I think the admissions that were made in the request for stay to begin with show that the really kind of tragic conditions that the respondent is experiencing. And we're not talking about just emotional, we're not talking about just physical, we're talking about both. I mean, she brought up both instances. She suffers from rheumatoid arthritis, which makes it difficult for her to produce documents. And she talked about fatigue, and she talked about depression. So I think that in and of itself, and the fact that in the disciplinary case itself, we looked at the record yesterday, Ms. Hughes and I did, there were a lot of deadlines. I can't tell you exactly how many, but a lot of deadlines for the filing of documents. With the exception of one occasion, the respondent never filed any sort of pleading in a timely fashion. In fact, the panel, the failing to file the exceptions is one thing. In addition, during the course of that proceeding, as I said, there was never a time absent, with the exception of one time where she filed a pleading in a timely fashion. And the respondent really admitted in her request for stay that her health has prevented her from filing things in a timely fashion. She has constantly cited her emotional and physical issues for the reasons as reasons for not complying with the orders of the hearing panel. There's additional evidence that would indicate that the respondent is unable to defend herself in these proceedings, and again, it arises from the motion she filed requesting a stay. She cited two cases. One of which she is presently involved, the other ended in 2016. The Vanderbilt Pool case, which is a criminal case where she's representing the appellant in the case. She was ordered to file a brief by July 5th after a couple of extensions. She did not do so. The Court of Appeals then issued a suspense order on July 26th, directing that the brief be filed on August 15th. If not filed, the Court of Appeals said that this possible consequence is that this appeal will be dismissed. No brief has been filed. Fortunately, the Court of Appeals didn't dismiss the appeal, and on September 18th, the respondent filed a motion to stay the criminal proceedings. It's almost an identical motion to what she filed in this disciplinary case. Because of my emotional and physical status at the present time, I just can't do this. I can't get this brief in. And the Court of Appeals granted the stay, but said that she, by October 26th, needed to provide a status report for herself on what her condition was. And then she cited a second case in her motion for stay, which basically said, I represented somebody in a civil rights action that I filed in 2013. The case was dismissed because I didn't respond to a summary judgment motion. And I was just physically and emotionally unable to carry out that duty for my client. This was in front of Judge Robinson in federal court. And in dismissing the case, Judge Robinson noted the many dilatory filings and missed deadlines in the case. And there was never actually a formal motion to continue, or not to continue the case, but to allow her to file a summary judgment motion out of time. The respondent requested the extension of time through emails to the court, which the court said, we needed some sort of formal motion filed. It's not appropriate to go ahead and ask me by email to give me more time. After all of this, after our request to place this, for the relief we requested, you then issued the order to show cause. And obviously she's here today. In the order to show cause, the respondent was given until October 12th of 2018 to reply to our response to her request for a stay. She did file a response on October 12th in which she asked you to consider her exceptions in determining whether she should be allowed to continue to practice and to defend herself. And as I said, this morning at 4:30, she attempted to follow those exceptions. It's our position that the two cases that I've just discussed and the respondent's own disciplinary case indicate, and by her own admission, that her health and emotional problems prevent her from capably defending herself. But she came to me this morning and she said to me that she wants to finish this. She wants to do it. I think there's plenty of evidence for you to make a determination that she should be placed on disability and active status until a determination can be made whether or not she is capable of doing this. It's really more than just her defending herself in this disciplinary case. It's also the fact that she's defending other people, and the Vanderpool case and the Birdsong case, the civil rights case, show that there is harm being experienced by clients. That's my understanding from talking to Ms. Hamilton this morning, correct me if I'm wrong, that the only case in which you're now involved other than the disciplinary case is the Vanderpool case. Is that correct? So there is just that one case. So I guess in conclusion what I would say is I think the evidence is there that the respondent is not capable of representing herself. She's going to tell you that she is and that she wants to continue doing this. I think that a possible resolution of this issue would be to place her on disabled and inactive status under Rule 220C and you have the authority under 220B to go ahead and order her to be evaluated, which I would ask that would happen immediately, to see whether or not she's capable of two different things: defending herself or representing somebody else. I think that's the safest way to protect the public, and frankly to protect her. I mean, if there is only one case out there where she's representing somebody, I mean that easily could be handled. That could be, someone else could be appointed to do that. One other thing that's contained in Supreme Court Rule 220B is that you have the ability, and I've never seen this happen before in all the years I've been doing this a lot, you have the authority under that rule to appoint counsel for Ms. Hamilton. And I think to guide her through this process, which frankly is kind of new to me, got to be frightening to her. I think it would be, I would request that the court do that. I think it would be helpful to her. But at this point in time, it's just, from our perspective, and there are some findings made by the panel itself. If you look at the final hearing report, they listed 10 instances where the panel was troubled about the respondent's appearance representing herself, because she's always represented herself. She's never had counsel representing her. They talked about she failed to bring certain exhibits to the hearing. There was disorganization. There were unfounded accusations. There were inconsistent statements. There was she testified about her failure to pick up her mail. She didn't pick up her mail very often, and so she missed some notices for some hearings. Not our hearings, not the disciplinary hearings, but other hearings. And there were repeated efforts on her part to introduce evidence which the panel had told her she couldn't introduce, in a motion in limine that had been filed by our office. So I would urge the court to have her be evaluated. It just seems to me to be the logical thing to do, the right thing to do. Maybe we can all find out a lot, and maybe that will help her too. Be happy to answer any questions.
Any questions of counsel? Thank you.
May it please the court. I am Rebecca Hamilton, and I represent myself pro se in these proceedings. I'm here to ask you not to put me on disability status. I believe I am quite capable of representing myself. I have done so for, I guess, 3 years in this case. And we are at the finish line. I have had difficulty with deadlines in this case, and I did have difficulty in the Birdsong case, meeting deadlines. That isn't due to specifically to any mental disability. There has developed physical issues that do make things a little more difficult. Rheumatoid arthritis is one of those things, and it can slow me down for sure. But I would like to point out that we're just inches away from finishing this. I have completed the responses, and they're very lengthy. And what the next thing that would need to happen would be that if you allow me to, I will compile those, reorganize those in terms of a brief, and we're there, and it won't take much for that to happen. I would like to explain a little bit about how this difficulty in meeting deadlines occurred. It occurred right about the time that my motion for summary judgment in the Birdsong case was coming up. In addition, this disciplinary case began, in April of 2015. I was trying to get credit for some courses I was taking with the National Association of Defense. They provided what I considered to be like graduate level CLE for people who do criminal defense. The kind of courses they taught were really about things that I needed to know about in my practice. So I had attended those along with about, I think, 5 hours of normal CLE, and I began trying to get credit for those NAPD courses. And I was instructed to try to have them, I could pay $100 each course and fill out an application, or I could go to them and have them fill out an application that would include, how they kept attendance, so forth and so on. So I began that process of trying to figure out how to get these accredited. That process, I finally figured out I needed to have them fill out this application, and that was ultimately accomplished. But in the meantime, during this time, I was in constant communication with them, telling them, I'm still a little confused about what I need to do to get these done, but I am doing that. Please don't give up on me. And no, I wasn't receiving, much was made about the fact that I didn't receive the notices that were sent out about CLE compliance, as if this was a plot on my part to pretend I didn't know what was happening. Much was made about the fact that the notice was sent to my registered address. What happened was, unbeknownst to me, I had checked as my preferred mailing address my home address instead of my business address. I don't even recall why that was done or if I just made a mistake. But instead of the notice going, to my last known address, it was sent to my home address. I have 2 known addresses. And I wasn't that, diligent in picking up my home mail. I was very diligent in picking. But despite the fact that I wasn't getting these letters, I was in contact with them when they emailed me the notice. Anyway, I had a conversation with Miss Sutton on the 6th, and she told me, your license has been suspended. I was shocked. And all of this is in my request to be reinstated to this court. And I gave that explanation. My license was reinstated. But and I did practice for 3 weeks, not knowing that I had been suspended, because I thought Miss Sutton was saying, okay, I see what the problem is. Just send me what you have. I explained to her that I had had difficulty, but I had all the material ready to send her. Somehow, what I mailed, she never received. I didn't get it back, but somehow that didn't get there.
Excuse me.
I'm sorry.
I'm sorry, counsel. You have a little less than 8 minutes left, and you're entitled to make whatever presentation you want. But at some point in the 8 minutes, are you going to respond to Mr. Hazlitt's recommendation and what brought us here today, that we enter an order transferring you to disability and active status? I know you've said we're close to the finish line, there's no need, but if you could provide some examples besides that as to why we should not do that.
All right. Well, my main thing is all of this amounts to me trying to put forward what I know to be true in a lot of cases and being unable to do so. And the frustration of having all of that just be wiped clean because there was an intentional intent in the people who filed these complaints, which would be Ed Braincards, at the time that he filed his disciplinary complaint that I was practicing law without a license, there was a pending motion that I would be able to present the fact that police reports had been withheld intentionally for 4 months in a juvenile case. That hearing never took place because of his disciplinary complaint. The minute he filed his complaint, the entire district court in Wyandotte County began precluding me from representing clients. They filed a motion called Motion to Remove Counsel for an Ethical Violation. They found me guilty that day that they filed it. They had a hearing. I was not invited. My clients were not allowed to object to that. All of my cases disappeared.
You, at that stage, you were unlicensed.
No, I was licensed.
Okay, I didn't understand.
Well,
You
I mean,
were on temporary suspension at that point? Or,
no.
Or what was the basis of the motion?
the administrative
The
suspension
suspension is what I
had
had,
been
yes.
corrected.
It had been corrected at that point.
Yeah.
When the complaint was filed, it had already been corrected?
No.
No.
Okay,
Okay.
so,
I think we understand that part. Okay.
Okay.
Thanks.
When you first stood up, I understood you to say you asked that we not place you on disability status because you no longer, if you ever had any mental issues, they were now purely physical. So I'm asking you, what can you tell us to elaborate on that point as to why we should not do what Mr. Hazlitt's asking us to do?
I don't know what mental issues some evaluation would disclose. What? that it is difficult to be frustrated every time you try to present the facts that you have. In the disciplinary hearing, this motion in limine was granted that said, I couldn't call any witnesses. I couldn't call anyone from Wyandotte County. Why? They had no relevant evidence to present. How can you do that? Relevancy is one of those motions that probably needs to happen in the hearing, because relevancy can change at any time. And I was told that I couldn't present any evidence other than, were you suspended and did you practice law during those 3 weeks? I'm repeatedly told, no, you can't talk about that. If you want to bring that up in your testimony at the end, you can do that. Well, of course I couldn't do that. If I can't call those witnesses, I can't introduce the evidence that I have, I'm not going to be able to cover my entire case at the end. It's just impossible. And I guess a lot of frustration with, why can't I tell my story? When am I going to get that chance?
Counsel, I'm kind of dividing up our purpose here today into two pots. One is you're representing yourself, the other is the public, and I'm going to talk about the second one.
Okay.
One of the obligations we have is to make sure that licensed lawyers aren't out on the street able to do harm to people who need lawyers. And so let's just take the most, filing something at 4:30 in the morning.
I filed it yesterday afternoon.
Yes, okay. But filing it at this late date is sort of a warning sign, along with everything else, that there are problems in your ability to represent people that might need your services. So comment on that. What makes you think you're capable of representing people who may come in the door? And I'm assuming that in that question that you've only got one case pending right now. You've only got one client. Is that right?
Right.
Okay, so what tells us that you're capable of representing people when you've got this history?
Well, partly it is because at this point, I am very comfortable that if you will look at these facts, you will find that I have a lot of good points to make, a lot of important things that are actually causing harm to people, real problems. For example, I have evidence that, the Wyandotte County District Attorney was systematically keeping out exculpatory evidence, was ignoring and in fact trying to prevent exculpatory evidence from being disclosed. And that has caused a great deal of harm. It caused harm in my clients' cases. I mentioned the Berry case.
Well,
I'm sorry.
Counselor, I understood that your clients didn't get the relief that they were seeking in part because of your dilatory actions. What you admitted that your difficulties in meeting deadlines, and I think the question of my colleague is, even if your clients had a worthwhile cause of action, but they were not able to get relief because of your difficulties meeting deadlines, then why should we allow you to do that to any other clients?
Well, it's a lot more complicated than that. That just simply because I didn't meet a deadline means that that's what, prevented my client from getting the result he wanted. First of all, I
Well,
didn't.
okay. Does it harm your clients when you miss deadlines in their case?
Yes.
Okay,
And-
and so the question is, if you're admitting that you're doing things that are harming your client, my colleague asked, why don't we have an obligation not to allow you to continue to do that?
Well, that one deadline that you're talking about, Mr. Birdsong, was 2 years ago. That's the only one. And I would argue, I'm
Counsel,
sorry.
what about the deadlines in your own case, your own disciplinary matter? Do you dispute Mr. Hazlitt's representation to us that there's only been one that has been observed?
I'm not sure how many. Okay. One reason is this.
No, I'm just asking about the fact now, just the fact of whether you've met deadlines in your own disciplinary case. Do you dispute his representation about your ability to do that, your apparent ability to do that based on the historical record?
I do dispute that that has helped or prevented me from representing myself.
Now, that's not my question. Did it happen? Did you miss deadlines in your own case?
Yes, I think so. I'm not really sure exactly, but I do know I did ask for continuances. As far as the first hearing, there was 6 months between the first hearing and the second. That was not at my request. In fact, I was not consulted at all on any deadline.
So you dispute the fact that you asked for continuances, that you had health issues in between the two?
I'm not disputing that I never ask for a continuance. No,
I thought you
didn't.
just said you did.
I'm saying that after the first hearing, which was held
Right.
appropriately, there was a 6-month gap. I objected to that via email, but consequently, I was kind of at a disadvantage. We had half the hearing, and I don't know why there was a 6-month continuance, but I assume that during that time, things were being mulled together and processed and so forth.
Can I ask you something?
Sure.
We're out of time, and
I'm sorry.
Mr. Hazlitt is requesting, one, that we do proceed with the response, and that is to place you on inactive disabled status. But also about that was that you undergo some sort of evaluation. And I think you just said that wouldn't be very helpful, but even in your request initially to stay the proceedings, you said that you suffer from rheumatoid arthritis associated with fatigue and depression. What is the problem with assessing that? The fatigue, the depression that is associated, that you admit is associated with your condition?
Well, what's the problem with it? Like I said, I have no doubt that in this case, I am prepared to finish it.
Well,
right
are
now.
you saying you wouldn't cooperate with an evaluation if that's what we ordered, or would you?
Oh, of course I will. I'll do whatever you say.
And the other thought that he had is, what about appointing counsel to assist you in your representation?
If that's what you want to do, I will obviously cooperate. I don't think it's necessary. I don't think it will. This whole thing of we're afraid she just can't do this, can't properly represent herself. If that's what we're here about, it sounds a very kind of protective of me. We're doing this for your benefit. This is to help you. I'm saying, just let me finish. I can do this. It's ready to go.
And
We're
are you
also,
ready?
as Justice Biles indicated, we're also looking out for the welfare of the public.
Is that why we're here?
Well, there are several reasons for our being here, and that is one of them.
I would ask that you not decide whether I'm capable of representing anyone else at this point, because I'm not prepared to explain to you why I believe I am. That will be the issue, I believe, that you'll decide after you read my brief, after you read these exceptions.
Justice Liquid, you still have a question?
I was just gonna ask, are you prepared and able to file the brief in the Vanderpool case in a timely manner now?
Yes.
So you will be responding on the 26th with the brief, or?
Yes. And I would ask you to perhaps take this under advisement. Let me file that brief. Let me file these exceptions. And then, if you look at those and say, she's off her rocker, she can't do this, then you say, we're going to have to intervene. But I'm saying I can do it, and I want to do it, and I'm capable of doing it. And it would be really an unnecessary delay in getting this accomplished.
Do we have any more questions? Thank you, counsel.
Thank you.
Excuse me, I really just wanted to say one thing. Ms. Hamilton's right. She filed it at 4:30 yesterday afternoon, not 4:30 in the morning. I misunderstood what the clerk's office told me, but nothing has changed my recommendation to the court. Unless you have any questions.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning and this afternoon. Clerk will take this matter under advisement. That concludes